Mr. M is one of the 4 partners in Measures XY Enterprises. He owes a sum of 6 crore to his friend Mr. Z, which he is unable to pay on due time. So he wants to sell his share in the firm to Mr. Z for settling the amount. In the light of provisions of Indian partnership, discuss each of the following. Can Mr. M validly transfer his interest in the firm by way of sale? So what has happened here? M has taken money from someone. He is not able to repay. Can he sell this interest in the for the loan that he has taken? Is it possible? You have to do it only after the consent of all the partners. But can you pledge? Can you do all of that? Answer is directly no. There is a restriction, but after the approval, yes, you can do. A transfer of partners' interest in the firm is absolute or by mortgage or by the creation of any charge or such does not entitle the transferee during the continuance of the firm to interfere in the conduct of business or to require accounts to inspect, but transfer only to the. Yes, Mr. M can validly transfer his interest in the firm by way of sale. When, if at all the others are not willing to buy it, then I can sell it. There is no restriction on that. Agreed? Okay, next one. What would be the rights of the transferee in case M wants to retire from the firm after a period of 6 months from the date of the transfer? Rights of transferee. You cannot inspect the books. You cannot interfere in the conduct of the business. You cannot require the books of accounts. So that is your rights. Simple. That's my provision. To receive the share of assets, for the purpose of asset in day. I also fell for it. What would be the rights, da? What did we say? We said restriction. You wrote restrictions only, Rights, people. What are the rights? I'm entitled for my share of profits every month. If at all we are entering into dissolution, I'm entitled for the share of my asset and also I'm entitled for the accounts from the dissolution order. That is my right. My God. Durandar. Hey, exam, this is how it happened. And I also fell for it. Bhagwan. Mr. Raj formed a company with capital of 50,000. He sold his business to another company for 40,000. For the payment of sale, he accepted shares worth 30,000. The balance 10,000 was considered as loan and Mr. Raj secured the amount by issue of debentures. By now only you should know which case. His wife and 3 daughters took 1 share each. Owing to the strike, the company was wound up. The assets of the company were valued at 6,000. The debts were 8,000. Mr. Raj retained the entire sum of 6,000 as part payment of loan. To this, other creditors objected. Their contention was that a man could not own any money to himself and the entire sum of 6,000 should be paid to them. Examine the rights of Mr. Raj. What is the answer? Remember, people, separate legal entity. The shares, the shareholder is different and the company is different. As Mr. Raj had a secured debenture, he will be given the priority in repayment because from the company's point of view, both are seen as outsiders only. Why corporate will? Why are you lifting corporate will? Simply, sir, anywhere they lift it. No, separate legal entity. What did he do injustice? What is the case law? Salomon versus Salomon. You will give a reference to Salomon versus Salomon. That case law you saw under separate legal entity. Where? Huh? Lifting of corporate will. Okay. Yes, that too. Lifting of okay. Corporate will is yes. That is nothing but separate legal entity. Lifting of corporate is you're lifting the identity of separate legal entity. That is okay. Lifting of corporate will Allah. Salomon versus Salomon. This is very, very important. That case should be mentioned in your answer. Okay, based on that, whether Raj can take it? Yes, because he has a secured debenture. BC Private Limited and its subsidiary KL Private Limited are holding 90,000 shares and 70,000 shares respectively in Aha. BC and its subsidiary. This is holding are holding 90 and 70,000 respectively in PQ. The paid up share capital of PQ is 30 lakhs. The total PQ's capital is, or basically take it as 3 lakhs. That is total paid up capital. Okay, analyze with reference the provision of Companies Act. Hey, 9 plus 7 how much na? 16. So 1 half is 1.5. They are holding 1.6. Add these two. What is the provision? Write down subsidiary company. 2 clause 87. A company in which majority of the board of directors are controlled. Composition of board of directors, or when a company either on its own or together with its subsidiary controls more than 1 half of the total voting power, either on its own or together with its subsidiary. So I will be adding 90 plus 70k. That's my provision. Yes, PQ Limited is a subsidiary company of BC Limited. What would be your answer if KL Private Limited is holding 1,60,000 shares in PQ Private Limited and no shares are held by BC? They are telling in second scenario. What if KL only directly holds 1.6 lakh? Then what will be the scenario? Deemed subsidiary of whom? PQ will be a deemed subsidiary of BC Limited. Remember. Hello? KL becomes a holding, but BC Limited will become the ultimate holding company. So it will be, you need to write the word deemed subsidiary company. Okay, next one. A company ABC Limited as on 31st March 2025 had a paid up capital of 1 lakh. In June 2025, ABC Limited has issued additional 10,000 equity shares of 10 each. Out of 10,000 shares, 5,000 of these shares were issued to XYZ Private Limited. XYZ is a holding company of PQR Private Limited by having control over the composition of its board of directors. Okay, how many companies came? Okay, XYZ is a holding company of, okay, ABC has a total paid up capital of 10,000 equity shares. In June 2025, ABC Limited has issued additional 10,000 equity shares. So totally how much they have? 20,000 shares. Out of 10,000 shares, 5,000 of these shares were issued to XYZ. Okay, in that 20,000, 5,000 is held by XYZ in ABC. Okay, now PQR Private Limited claims the status of being a subsidiary of ABC Limited. PQR Private Limited claims the status of subsidiary of ABC Limited. That is XY. Okay, wait. ABC Limited as being a subsidiary of its subsidiary, that is XYZ Private Limited. Examine the validity of the claim of PQR Private Limited. State the relationship, if any, between ABC Limited and XYZ Private Limited as per the provision of Companies Act. Tell me, people.
Relationship between ABC and XYZ is an associate company.
Very good. The people, ABC totally has 20,000. In that, how much am I holding? 5,000 shares. That is nothing but 25%. Definitely, I am not a subsidiary company. They are not holding anything here. So there is no relationship of subsidiary holding company here. But XYZ is holding 5,000, which is 25% of its total shares. So this, what type of company it will become? It will become associate company. Clear? Correct? Whether PQR is a subsidiary company and XYZ is it a holding company?
What?
No.
XYZ PQR is a subsidiary.
No, sir.
But so the question was like whether PQR is an
What are they asked?
It is written now.
PQR, XYZ is a
PQR.
holding company. They have
Now, PQR Private Limited claims the status of being a subsidiary of ABC Limited as being a subsidiary of its subsidiary, that is XYZ Private Limited. Is PQR a subsidiary company? No, ABC is not holding anything in PQR, no.
ABC itself, it's not a subsidiary company. Then.
Correct. So is it? No. But is PQR a subsidiary of XYZ? Yes. Why?
They have
They mentioned that XYZ is a holding.
so
They shouldn't have said that, but they should have given it to you this way. When one company controls the composition of board of directors of another company, you will be deemed to be a holding subsidiary company. Remember that. That is what we wrote to the left. Majority of directors. Hello? Clear? Huh? Okay. Do you agree that a company is an artificial person? Yes, that's all done. Elucidate. Also explain how the authorization by Beta Limited, a company incorporated under companies that can be made in case it does not have a common seal. So if a company does not have a common seal, you need to sign it by 2 directors. If at all you have a company secretary, it will be 1 director and 1 company secretary. That is answer, huh? Okay. Narendra, we have not written, right?